CR-19-592, Howard Wood versus the state from Scott Circuit, CR-19-299, Nicholas Addison versus the state from Poinsett Circuit, CR-19-563, Carl D. Prince versus the state from Sebastian Circuit, Civil Case 19-828, Tyron L. Jones versus Wendy Kelly as Director of the Department of Correction, an appeal from Chico Circuit, Civil Case 19-982, Walter Sims versus Wendy Kelly, Director of Department of Correction from Lincoln Circuit, and finally, Civil Case 19-983, Abraham Grant versus the state from Lincoln Circuit. In addition to those 11 cases, also being submitted to the court this morning are 22 of their various motions and petitions. All submissions and decisions on motions are available on the court's website.
Okay, thank you, Tracy. We'll now take up the oral argument case of CR-19-591, Vaughn v. State. Let me mention that Justice Hudson is participating by audio, but not video. And the court will recognize the appellate's attorney.
Thank you, Mr. Chief Justice, and may it please the court, I am Jeff Rosenzweig, and I've represented Tracy Vaughn in the trial court and continue to represent him here in this court. In 2016, law enforcement suspected Mr. Vaughn of sexual impropriety with a child, actually more than one child allegedly. Everyone was interviewed and no charges resulted. What then happened was the child was sent to counseling. And after more than a year of counseling, she purported to remember things that she had denied over and over again. Then the court, and so in 2018, the court, the law enforcement got a warrant. And in the warrant, in the affidavit for the warrant, they specifically stated that the child had made this disclosure in a therapy session. Therefore, we requested all the records from the therapy, from the counseling or therapy sessions, both before and during the trial, and were repeatedly denied. And this denial occurred even after the child mentioned it in her examination at the trial. The distinguished circuit judge, and he is retired now, but the distinguished circuit judge had read this court's precedents to deny all access to these under any circumstance. We submit that he erred in this case, and this case presents the opportunity for the court to clarify what the appropriate standards are. And there are a number of reasons the court erred. First is the fact that there was a waiver in trial when there was a discussion about it. Rule 510, which is the waiver rule of the Arkansas Rules of Evidence, specifically does not talk about parties, it talks about persons, not parties. Secondly, with regard to Ritchie, Ritchie makes clear, Ritchie and Hafner, which is this court's gloss on Ritchie, make clear that the privilege is not necessarily absolute. It depends on the particular circumstances of this case, of a case. And two of the leading cases in this that the court apparently relied on are distinguishable from this case. Johnson versus State dealt with a situation where the court found that this was totally unrelated, that the counseling was totally unrelated to a prosecution. And that clearly is not the case here. In this circumstance, when one were to, if one, as the circuit judge did, look at the records, he would have seen that the records reflect that the counselor was helping the child develop a so-called trauma narrative for the purpose of having another interview with the Child Advocacy Center. And the Child Advocacy Centers clearly are part of an investigation. And of course, the fact that the disclosure of the allegation was, and the reference to it being in counseling or therapy was in the affidavit shows too that it was part of the investigation. Holland, which was another case that the court apparently relied on, Holland dealt with a situation of what was a pre-investigation motive issue, and did not deal with essentially an attempt to create or develop, or whatever a verb you want to use, testimony. Now, the state in its brief relies heavily on Jaffe versus Redmond. Our position is Jaffe versus Redmond is essentially irrelevant. It is a federal civil case, doesn't even mention the Constitution, doesn't even mention criminal cases. It is merely the United States Supreme Court using its power to recognize a psychotherapist privilege in the context of a civil lawsuit in federal court, and that's all it stands for. There's several other reasons why the court erred. One is the state had possession of the materials. The state was the one who gave them to the circuit judge. So there's a Brady issue there too, as well as a discovery issue of Rule 17.1, reports and statements of experts. Another reason is essentially the shield and sword problem. This court's doctrine, as essentially every court has, is that you can't use the same doctrine for both as both a shield and a sword. The state, the law enforcement, the state used the alleged disclosures in the therapy session as a sword, and then attempted to drape a shield over it. We submit that that's improper on that basis as well. Related to that, of course, is the doctrine of estoppel. That essentially it's taking inconsistent positions. Again, they use the disclosures to get the warrant and to present the testimony, but won't let us have any access to it. Obviously, also that this is an incursion. We have submitted this as an incursion on the constitutional right to present a defense, even after the child discussed this to some extent in her testimony. We were denied the opportunity even to properly cross-examine her, even outside the presence of the jury. That is an incursion on the right to present a defense. Court of Appeals held that we were entitled to this material, but it was harmless. It was harmless error, and that's erroneous on a number of grounds. First, of course, we get into the question of what is the proper standard of review. We say it's the Chapman standard, the harmlessness beyond a reasonable doubt, because it is a constitutional issue. But even
Mr. Rosenzweig.
Yes, Your Honor.
And if I can interrupt you, can we visit a little bit about your Brady allegation and the allegation that the state had a requirement to turn these over because they accessed them? And what I heard from you just now was that because the state turned them over to the circuit judge, but my understanding from the appellee's brief is that the state only obtained them in response to your motion for the judge to review them in camera. And so the state's response was they obtained the records just to turn them over to the circuit judge. Are you saying that alone constitutes state access for Brady implication?
Well, we don't know. We don't know if the state looked at them or not, actually. But if they looked at them, clearly it's Brady. We would submit that if they have possession of them, they should have looked at them. And our position is they can't get rid of their Brady obligation by a form of willful blindness.
Well, so let me follow up that what you're saying is, so if defense asks for an in-camera review under Ritchie of confidential privileged information, and so the judge says turn it over, and so the state has the alleged victim provide it to turn over to the judge, that will always now implicate Brady. So we've basically, you've done an end run around Richie.
Your Honor, I think the appropriate way to do that would be to get it understood on the front end what the state's whether the state is going to look at it, not look at it, et cetera, on the front end. Brady was not the centerpiece of the necessarily of the argument, and our submission, we can win even if you don't get to the Brady issue.
Well,
but
did you ask the circuit judge to order them not to review it when they were obtaining it for the in-camera review that ultimately didn't happen? Did you ask for them, the judge, to order them not to look at it?
Well, Your Honor, maybe I misunderstood what you just said, but if you said the in-camera review did not happen, the judge was pretty clear that he did the in-camera review.
He just didn't make a determination.
Well, Your Honor, I don't recall whether I asked one way or the other on that. I don't think I did, but I'm not totally sure on that. But the judge did, before the trial, do an in-camera examination and determined that there were things that he thought we would be interested in, but he held the privilege was absolute and we were not entitled to it in any way, manner, shape, or form. I hope I've answered your question adequately, Your Honor.
Thank you.
Okay, but even under the more flexible, reasonable probability standard, we should win as well. And there's several things the court can look at. One is Mr. Vaughn was only convicted of one of the 4 counts which the state brought. There was a directed verdict on one. He was acquitted on 2 others, and he got the minimum sentence on one. Secondly, Your Honor, the idea that Mr. Vaughn had admitted to non-sexual gratification touching should not be the be-all and end-all. Number one, the law is very clear that random accidental touches are not criminal. They are not for sexual gratification, nor are parental touches for other purposes, say the application of medicine. Now, Mr. Vaughn was, in fact, the parental figure. The state appears to downplay that. However, if the court can look at the mother's testimony on cross-examination, where she admits that Mr. Vaughn was the closest thing to a father the child had ever had, he was the one who took her to school, picked her up from school. She hung out with him at work. Mother worked nights and sometimes didn't come home at night. He fixed the dinners. He took her to the learning center and every place else like that. He is clearly someone who is in a position where living closely with the child. And of course, she said the child actually slept between Mr. Vaughn and the mother at night. That is clearly a parental figure. Mr. Vaughn was simply not a random person in the park somewhere. The issue also of with access to the records, we would have been able to conduct a searching cross-examination of the therapist, and I think there's a basis for she was talking about making memories, or I'm not sure she used the term recovering memories, but I think that's what she was getting at, which is of course is a methodology which is seriously controversial, and seriously we should have been entitled to get into that under any standard, Chapman or any other standard. A jury that acquits Mr. Vaughn of some of the allegations and which sentenced him to the minimum sentence on the one on which he was convicted is a jury that would have been interested in how that story developed.
Mr. Rosenthal, may I ask a question? This is
Sure.
Courtney. You have referred to Richie throughout your briefing and even this morning, and that Tafner is our gloss on that. My question is, does Richie even apply here? Because I'm wondering about there being a significant distinction between what we have right now, these therapist-patient communications, and on the other hand, in Tafner, where we had child maltreatment reports and DHS records, and how the statutory scheme is different for both of those. So I guess my question is that a distinction without a difference? Or is that one that would take this out of the Richie universe?
Your Honor, let me try to answer it this way. Richie held that under the particular facts of Richie, the court should have looked at it and determined whether there's anything material. Some courts have held that have gotten onto the fact that the particular matter that was discussed in Richie had some exception from absolute privilege. Tafner recognized that. What we have here is an exception from absolute privilege under a number of ways. Number one, this case is distinguished from Johnson for the reasons I said. It's distinguished from Holland for the reasons I said. It is also, and we also have a fairly blatant waiver during the trial. And so for all of those reasons, we should have been entitled to them. And and if one is interpreting Richie to say that under some circumstances they're absolute privilege, but under some circumstances they're not, and that we're clearly on that side of Richie. I hope that's answered your question adequately. And if the court doesn't have any further questions, I will defer to attorney for the appellate at this point.
Okay, thank you. And the court will recognize the appellee's attorney. Ms. Rump. You're still on mute. You're still on mute.
Is that better?
Yes.
Thank you. I'm sorry, Your Honor. May it please the court, I'm Pamela Rumson. I represent the state here this morning. No one disputes here that a touching occurred and that the touching of the victim was no accident. Prior to trial, the defendant gave a lengthy statement to the police, which was played for the jury, where he admitted that he touched the 9-year-old victim's buttocks and vagina as she was in a bathtub. The victim also testified that the defendant came into the bathroom when she was in the bathtub, started touching her vagina, stuck his hand under the bathwater and started touching her vagina, and he touched her vagina 4 to 5 times. So although the state believes that the trial court correctly ruled that the sealed records are privileged under Arkansas Rule of Evidence 503 and the statute 1727-311, the state also believes the court doesn't need to reach this privilege issue to affirm this case. It can affirm on the alternate basis that the sealed records were not material under Brady. Why aren't the records material? Well, under Brady, of course, materiality is defined as a reasonable probability that the outcome of trial would have been different had the undisclosed information been disclosed. The defendant was convicted of second-degree sexual assault, which requires sexual contact with a person under the age of 14 who is not a spouse. Sexual contact means any act of sexual gratification involving the touching, either directly or indirectly, of the sexual organs or buttocks of another. Here, of course, the touching of the buttocks and the vagina is admitted, and the defendant admitted the touching was not accidental. Thus, the only remaining issue in the case was whether the touching occurred for sexual gratification. And as the Court of Appeals correctly found, the undisclosed records shine no light on that question, and therefore they're not material under Brady. At trial, remember, the defendant sought access to the undisclosed records of the victim in order to cross-examine her with her initial reluctance to admit that the defendant had touched her vagina. And it's true that the private sealed therapy records, the ones that were undisclosed, contain information that indicates that the victim was in therapy for several months before she admitted in May of 2017 that the victim had indeed touched her privates in the bathtub. But the issue of whether the touching occurred was not contradicted at trial. And as the Court of Appeals noted, the defendant's version and the victim's version did not contradict each other on this point. The Court of Appeals also noted that the defendant was able to cross-examine the victim on the very matter he wanted to cross-examine her about, that being her initial reluctance and or denial of the vaginal touching through the statements the victim gave to the Child Safety Center, to the statements she gave to Felicia at the Child Safety Center. Those statements were provided to the defendant, and he used those statements to cross-examine the victim about the very matter he contends he needed the child's private therapy records for. When she was cross-examined at trial with the records from the Child Safety Center and asked about her initial denial of the vaginal touching, she admitted on cross-examination that she had indeed told Miss Felicia at the Child Safety Center that she didn't admit it right away. And in fact, she had denied it to Miss Felicia 2 times. She also testified on cross-examination that the reason she had not admitted it initially was that she was afraid. So therefore, the purported use of the sealed records was accomplished by records that were freely provided to the defendant. The defendant says that there's a problem because he was entitled to look through the records to see whether there was anything else of interest in there. But that's not true. He's not entitled to paw through private records of a victim in a case. If the defendant thought this was Brady material, the trial court, although correctly ruling it privileged, also undertook an examination of those records and found that it wasn't going to rule on the Brady issue, but the Court of Appeals did. The defendant got exactly what this court found proper in the Holland case. In Holland, there was an issue of privilege raised, and the issue was sort of pushed to the side in that case because the defendant, Mr. Holland, had received other records that disclosed the same information that the sealed records that he was denied access to contained. And this court undertook a review of those records and affirmed the trial court's decision that those records were not exculpatory under Brady. And in fact, this court found that in Holland, the undisclosed record had scant evidentiary value. Well, although the trial court here didn't undertake the review mandated by Brady, the Court of Appeals did. And the Court of Appeals did everything that it was obliged to do under Holland, and it concluded that these records were not material. And in fact, probably less material than in Holland, because here they don't even have scant evidentiary value because records that the defendant was provided contain exactly the same information. I would like to address, however, several what the state sees as misstatements in what the defendant has said here this morning. First of all, the state stated on the record that these children, if you recall, there were three victims at first. And then he was charged with the sexual assault of 2 of the victims, but only found guilty of the sexual assault of KH. And the state stated on the record in August of 2018, when the parties were discussing these records, that the state had nothing to do with sending them to therapy, contrary to what the defendant has said here this morning. In fact, these girls, at least KH, had been in therapy since she was 5 and continued in therapy for several years. The therapy had stopped. And then after she was sexually assaulted by the defendant, she went back to therapy. But the state stated, uncontradicted on the record, that it had nothing to do with sending her to therapy. Thus, if we're going to reach the privilege issue, it's not waived by the fact that this little girl went to therapy, nor is it waived by the fact that she mentioned therapy when she was cross-examined by the defendant at trial. She did not testify about her therapy on direct examination. She testified about her therapy when she was cross-examined by the defendant at trial. The defendant simply isn't allowed to bootstrap a request for inadmissible privileged information by opening his own door by asking the 9-year-old victim about her therapy. The record is also clear, Justice Wood, that the state, quote, did not have access, did not seek to admit the records, and had no intention of calling a therapist at trial. It's the state's position that it acted as a mere conduit for a judicially compelled disclosure between the therapist and the judge. That can't be possession for Brady purposes. The state will admit that it has looked exhaustively for cases about what constitutes possession under Brady. And it can find no case that holds either way, that temporary access by the state is or is not possession for Brady. But here, there's no indication on the record that the state looked at those records. And it's one thing for the defendant to say that the record is absence of such evidence, but it's also the defendant's obligation to establish a record sufficient to support his claim. And the state testified, or the state admitted at trial, that it got the records pursuant to the court's request, which ultimately, I guess, was the defendant's request, as Justice Wood noted, and that at some point they were turned over to the judge. We don't know when they were turned over to the judge. We just know that the judge had them in August of 2018 at the hearing. We don't know how they were turned over to the judge, when they were turned over to the judge. We don't know whether the state looked at them. We don't know we know that they were, we know that 2 sets of the 3 sets were faxed to the prosecutor pursuant to their faxed subpoena. But we don't even know how the third most important set of records got to the judge, because there is nothing in the record to indicate that the state even requested that third set of records. I guess it can be assumed or presumed that they did, but that is another area where the record is simply not clear.
Counselor, this is Courtney Hudson. If this court were to determine that Richie does apply, is Vaughn entitled to all of the counseling records?
Absolutely not. He is entitled to exactly what the Court of Appeals did. He is entitled to a judicial in-camera review of the records, which is what happened under Richie. And that's what the Court of Appeals did. In camera found they weren't material to the only viable or live issue at trial, that being whether the touching, the admitted touching, occurred for sexual gratification. And in fact, I'll note for the record, which is in the record, that even the jury recognized that that was the key issue in this case. It sent a note to the judge during deliberation asking to have sexual gratification defense, because the touchings were admitted, because the defendant admitted he had touched her vagina and he had touched her buttocks. And the defendant admitted in his statement to police that he was doing this while he was washing her, but he didn't rub on her. Well, that doesn't make any sense in and of itself, because when you wash yourself or another, you rub on somebody, you rub. And so, I'm sorry. And so the question was the sexual gratification. So long answer to your question, Justice Hudson, he got what Richie requires through the Court of Appeals.
Well,
and
counsel,
the Court of Appeals, yes?
Counsel, really the right to access is moot, because the Court of Appeals actually didn't even do a Richie examination. They just wholesale gave him access to all the records before they even did an in-camera review. And they've released everything to the defendant. So the defendant has everything. The only question is, now that everything's out there, did it impair his right to present a defense? I mean, the defendant has everything, right? I mean, he has everything.
Yes.
At this point.
Yes. And the Court of Appeals looked at it in the context of what the proof was at trial after the fact, and found that it wouldn't have made, which is traditionally how Brady is done, actually, because if you allege a Brady violation, it's that something was undisclosed at trial. So you backwards look to see whether the undisclosed information would have had, if there's a reasonable probability of a different effect, a different outcome at trial. So it's necessarily backward looking. But when you look backward, of course, you have to look at what the proof was at trial, what the defense was at trial, what the information was sought for, and then make a determination under all the circumstances whether it would have been material at trial. And that's what the Court of Appeals did.
But counsel, they gave, before they decided the appeal, they gave the defendant access to everything. So the defendant has everything.
The defendant at this point has seen everything. He did not see everything at trial, of course, right, but at this point he has seen all the records.
Well, and Counselor, that's what confuses me about your answer, is that it sounds like you bought into what the Court of Appeals did in pushing everything over to defense.
Well, I think the easy answer is that the Court of Appeals looked at everything and reviewed everything in the context of what happened at trial and made a determination that.
But isn't that the job of the circuit court? Isn't that what we talked about in Tafner? That's not what the appellate court does. That's what a circuit court would do.
Yes, but at this point, the record is clear and the Brady violation has been alleged. And so the Court of Appeals made the determination, whether in error or not in error, that the records were not material. We don't need another determination on that. We know the record is what the record is, Your Honor, and we know what the defense was at trial. We know what the testimony was at trial. We know what the records say. And so the Court of Appeals did exactly, in the interest of judicial economy, did exactly what it should have done. And that is said, we have all these records right here before us. We have the whole trial record before us. We have the defendant's statement before us. We have the victim's testimony before us. And given that the...
Counsel, I think part of the problem is the appellant on appeal did not raise or ask for remand for the trial court to determine whether or not there was exculpatory and material evidence. They waived that request they made at the trial court level. They did not raise that and ask for that relief on appeal.
Well, the defendant got more than he asked for in the Court of Appeals. He asked for, well, he's the one that raised Ritchie, first of all, where the materiality analysis was made, albeit in the trial court. But the defendant argued in his brief that this information was privileged, and it's clearly not. But the Court of Appeals didn't end its analysis there. It went on to look at it under Brady. And so the defendant got a windfall in that the court determined, it may or may not be privileged, but we're going to look at it under here to see whether there's any possible way that you can win. And I don't think you can fault the Court of Appeals for taking all the information that it had before it and making the determination that all courts say should be made wherever it's made. This court, although the trial court in Holland had reviewed the records in camera, this court undertook its own review of the records in Holland and found that they offered, quote, scant evidence that would have helped the defendant. So the Court of Appeals really didn't do anything different than what this court had done in Holland. And given the clear, overwhelming nature of the fact of these records and the fact that the victim was cross-examined by the very thing that the defendant says these records could have been used for, I don't see how the Court of Appeals could have erred in that manner.
Counselor, you don't think that the Court of Appeals, that decision compromised the privilege between a therapist and a patient?
I do. I don't think the records should have been disclosed in the Court of Appeals. I think that when there's an issue of privilege, the issue is the child or is the victim of sexual abuse in therapy with a licensed qualified therapist who is diagnosing or treating her and who is doing it in a confidential manner. And if those factors are met, then the records are privileged under 503 and 1727-311. But that cat's out of the bag. And so
thank you.
So we are with where we are. And I just don't believe the Court of Appeals can be faulted for looking at the records, especially in this case where there's absolutely no question, and deciding that there was no reasonable probability of a different outcome at trial. And the state would—
Ms. Rumps, excuse me, your time's concluded. Are there any questions by any members of the court? Okay, thank you.
Thank you, Your Honor. I'm sorry for running over.
A rebuttal for the appellant.
Yes, Your Honor, just several things. First, so the record is clear, the circuit judge gave us nothing, exactly zero. He said he had looked at the records. He said there was some stuff that he thought we would be interested in, but we couldn't get it because they were absolutely privileged. And as he said, that the privilege, quote, trumps the constitutional issue. So when Mr. Vaughn was convicted, I represented accurately to the Court of Appeals that I would have a lot of difficulty writing a cogent brief on this issue without access to the sealed records, which is exactly what happened in Johnson. And I was the attorney in Johnson, and I was one of the attorneys in Holland as well. Anyway, so the Court of Appeals gave us access to that, and it said, file your brief under seal, which is, of course, what we did. And so the court had, by doing that, the Court of Appeals, I was able to show the Court of Appeals, and of course this court as well, what the matters were that we were entitled to have. Whether or not it was whether or not the initial motivation was for investigative purposes or prosecutorial purposes, that doesn't end the inquiry, because the records clearly show that it became that they worked on her so she could give her trauma narrative to the Child Safety Center, which is, of course, even by statute, an arm of the prosecution. They're the one who developed
Mr. Rosenzweig,
yes.
Mr. Rosenzweig, if the court gets to the point of looking to see if they're material or not, at any point during the counseling sessions, was there a suggestion that the prosecution or the state or that anyone was pushing this young girl to change her story or was working with the government to confess to abuse? Because if so, I missed that.
Well, Your Honor, we weren't allowed to get into that. First, we weren't even told who the therapist was. We couldn't subpoena.
No, but Mr. Rosenzweig, we all have the records now. And yes, what you just said is that it shows that, and I'm asking you where, because I didn't see it.
Your Honor, there's references to the issue of retrieving, I forget the exact verb, memories. We're talking about preparing for the interview with the Child Safety Center or Child Advocacy Center. The problem is, though, Your Honor, we were forbidden from questioning the child outside the presence of the jury, making it proper outside the presence of the jury with regard to it. We couldn't, and of course, we couldn't subpoena the counselor or therapist to talk about it. So we don't know what all happened. We are restricted to those notations that were made in the record, which were made, of course, by the person who was doing it. We don't know what her practices were with regard to writing things down and et cetera. We don't know what her particular slant on recovered memory is or making memories are or anything of that.
Right, but there's nothing in there right now that shows that she was working with the prosecution or the state.
Well, there is the fact that she was helping massage the story into something appropriate for the interview at the Child Advocacy Center.
Right.
There is that, but without calling this person. Now, if I could very briefly respond to something else Ms. Rump said. Mr. Vaughn did admit to touching, of course, either accidentally at some points in the bathtub and others. Now, poor judgment is not a crime. It's not necessarily something that most people would do in terms of assisting a child of that age to bathe. But the operative question is whether or not it is a crime, whether it's for sexual gratification. Mr. Vaughn denied it, one way to look at the evidence is that the event was of such little moment that the child didn't remember it or didn't give it any any care.
Mr. Rosenzweig, one more question. If the privilege belongs to the patient, then where's the waiver by the patient in this case?
Well, when she testified under cross-examination without objection.
And you opened the door, not the state.
Excuse me?
You opened the door to those questions, not the state, correct?
Well, Your Honor, I asked the question on cross, the state didn't object. What's our position? That's a waiver. The state could have objected, the court could have instructed to disregard that question, to strike.
Was that the state's waiver or was that the patient's waiver?
Well, it's the patient's privilege.
You're saying the patient, the child made the waiver at that point. You're saying that the patient, who's the child, made that waiver at that point.
Yes, Your Honor, and of course that brings me to the other issue, which I mentioned in the supplemental brief, which we haven't really discussed, and the question is whether she's a de facto party. The child is a de facto party or not. But our position is that there clearly was a waiver there. And as well, of course, the state is stopped since the state actually put it into the affidavit for the warrant. So that's, I hope I've adequately answered your question, Chair.
But Mr. Rosenzweig, the Chief's question was about whether or not the child, the patient in this case, made the waiver or the state did. You said because the state did not object that they waived the privilege, but it wasn't their privilege to waive.
Well, Your Honor, the child waived the privilege by answering a question, and the state did not object and try to redirect anything in that regard. If you're, I mean, there was a waiver by testimony. The precedents of this court are replete with circumstances where the court has held that someone didn't object to something and therefore the objections waived, the privileges waived, et cetera, or even beforehand, if they could, in Dansby. And the fact is that she, upon a question of mine, she referred to it. It's our position, and the state didn't object. The state didn't ask to be stricken, disregarded, or anything else like that. And we submit that that was a waiver there. And I think the state would be stopped from claiming that there was no waiver.
Well, her testimony referred to the fact that she had therapy, which is not privileged, but how does that go into a waiver of the contents of the therapy would be one question I have. The other I would have is that do we have any issues on your point that the patient made a waiver with the fact that she's a minor in this case, and whether or not that minor was able to knowingly and intelligently make some sort of a waiver there? Do we have some problem with that argument? Well,
Your Honor, I mean, that's obviously an issue, but this gets into the whole constitutional, well, that, in other words, the state would have been in a, let's put it this way, a de facto in loco parentis with regard to that at that particular time. The state could, had the state objected to that at that time, I think that there might be more legs to that, but the child's on the witness stand. The state is the one purporting to protect her interests. So that's, and then, so I believe that's an appropriate analysis.
Thank you.
Okay, any additional questions by members of the court? If not, Ms. Rosenzweig, thank you.
Thank you, Your Honor.
And that will conclude our oral argument in this case. And court will be adjourned.